Hi, this is Bridging the Week for May 19th to 23rd, and today is May 27th, 2014. Good morning, I'm Gary DeWaal. If you live in the United States, I hope you had a relaxing 3-day weekend, but I also hope you had an occasion to reflect this Memorial Day weekend on the sacrifices so many have made on behalf of our country. They often paid a great price for all of us. In our financial services industry, there was no one theme last week in regulatory initiatives or enforcement matters. From a regulator's assessment of reforms related to dark venue trading in Australia, to enforcement matters in the UK involving the London gold fixing, not to mention ESMA in Paris seeking assistance on rules under MIFID II and MIFIR, and to another regulator's help for certain end users in the United States, the issues addressed were diverse and wide. However, one matter stood out: an SEC enforcement action that named the Chief Compliance Officer for allegedly supporting his employer's non-compliance with certain rules and concealing violations from the regulator. This is serious. Very serious. We have a lot to cover this week, so let's get started. The European Securities and Market Authority has issued a consultation paper regarding the recently amended Markets and Financial Instruments Directive and related regulation. MIFID II and MIFIR are comprehensive measures that, once finally implemented, will greatly increase regulation of European financial markets by requiring the trading of certain financial and commodity interests on regulated venues, quote-unquote, whenever appropriate, increasing obligations on certain algorithmic traders, and obligating speculative traders to limit the size of their net positions in commodity derivatives. Specifically, in its 311-page consultation paper, ESMA discusses various specific requirements it proposes to adopt, gives insight into its rationale, and asks for comment on its proposals. Among the broad area ESMA addresses are investor protection, pre- and post-trade transparency, data publication, algorithmic trading and direct electronic access, and commodity derivatives. Separately, ESMA issued a 533-page discussion paper on a number of related but quote-unquote more innovative and technically complex topics, to begin the process of ultimately adopting more specific requirements too. The closing date for responding both to ESMA's consultation and discussion papers is August 1st. The UK Financial Conduct Authority last week brought and settled enforcement actions against Barclays Bank and James Plunkett, a former director on its precious metals desk, related to the firm's participation in the London daily gold fixing between June 2004 and March 2013. During this time, claims FCA, Barclays failed to maintain adequate risk management systems to manage and oversee its traders' participation in the London daily gold fixing, and did not adequately manage conflicts of interest between itself and its customers. As a consequence, on June 28, 2012, Mr. Plunkett, quote, exploited the weakness in Barclays' systems and controls, end of quote, to avoid the banks making a required payment to a customer of $3.9 million, although the bank later paid the customer in full. At the same time, Mr. Plunkett was able to increase the value of his own trading book by $1.75 million. Barclays agreed to pay a fine of 26 million Great British pounds, or approximately $43.8 million, while Mr. Plunkett agreed to pay a fine of $95,600 Great British pounds, or approximately $161,000, and be banned from performing any role in connection with activity regulated by the authority. In case you're not aware, the daily London gold fixing is a price-setting mechanism that permits market users to buy or sell gold at a single quoted price. The U.S. Securities and Exchange Commission brought charges against the former Chief Executive Officer, the Chief Compliance Officer, and 2 lending officials at defunct Penson Financial Services for their role in the broker-dealer's violation of Regulation Show. According to an SEC complaint, Penson systematically violated Reg Show, quote-unquote, thousands of times from October 2008 to November 2011, when it failed to close out within the required time shares of stock sold by its customers, which the customers previously had purchased on margin, and Penson had loaned out to the street for its own purposes. The SEC charges that Thomas Delaney, the company's former CCO, was aware of and supported Penson's noncompliance when the firm was, quote, required to absorb the cost of compliance, end of quote, and intentionally conceal the violations from regulators. The SEC charges also that Charles Yancey, Penson's former president and CEO, aided and abetted the firm's violations by, among other things, quote-unquote, turning a blind eye to red flags indicating that the lady was aware of and substantially assisted the violations. The SEC also filed separate actions against Michael Johnson, a former supervisor, and Lindsay Wetzig, a former manager in Penson's security lending department, for their roles in this matter. Both persons settled their charges. The U.S. Commodity Futures Trading Commission implemented a number of actions last week to help end users cope with certain Dodd-Frank provisions. These included issuing a proposed rule amendment to exclude from the de minimis threshold specific to dealings with special entities certain swaps entered opposite utility special entities, as well as reopening the comment period related to hedging issues for market participants in physical commodity derivatives under last year's proposed position limit and aggregation rules. The former Chief Risk Officer of Deloitte LLP, James Adams, was charged by the SEC with violating auditor independence rules when he accepted without payment in 2009, quote-unquote, tens of thousands of dollars in gaming chips from a casino while he was the advisory partner on an audit of the company that operated the casino. Mr. Adams agreed to cease and desist from violating the relevant independence rules and not to appear before the SEC as an accountant for at least 2 years. CME Group brought 2 actions last week reminding members of the need to report block trades within required timeframes, while another disciplinary action stressed the importance of maintaining all books and records, including a complete audit trail that comprises all the required data elements for electronic trading systems for at least 5 years. The Options Clearing Corporation, 7 U.S. option exchanges, announced last week they had implemented enhanced pre- and post-trade monitoring to reduce the risk of errors or other inappropriate activity that poses a material risk of significant market disruption. And finally, 2 things. The CME has delayed until August 1st, 2014, the effective date of its recently revised rule and guidance related to exchange of futures related positions. This revised EFRP rule and guidance previously had been scheduled to take effect June 2nd. And ASIC reviewed rules it imposed last year to help combat certain concerns it had regarding dark trading venues. It said those rules were effective. Well, that's it for this week's Bridging the Week. Remember, there are always more articles and more information in each article in the article version of Bridging the Week on this website. Check it out. Until next week, wait, you don't have to wait until next week, because this week I am serving as guest editor of John Lothian News. Check out my commentary there every day this week, today through Friday. However, until next week on Bridging the Week, have a great week. Ciao!